question that a lot of people ask me when they first call my office is, what's the difference between a Chapter 7 and a Chapter 13 bankruptcy? Well, there are a lot of differences, and to cover all those in depth, you'd probably need to contact my office and we can talk about that. But to give you a little overview of what we are talking about in differences is Chapter 7 bankruptcy is called a liquidation bankruptcy, where any non-exempt assets would be liquidated and potentially turned into cash and distributed to creditors. Now, it's very likely that in a Chapter 7 bankruptcy we could find a way to exempt most of your assets if you could qualify. Difference in a Chapter 13 bankruptcy, where if you had non-exempt assets, we could keep those in a Chapter 13 bankruptcy by agreeing to make a payment plan with the court. So by paying a percentage of your debt, 20%, 10%, 30%, whatever it may be, you have to calculate your different means test versus some of the other means tests we see, determine how much of the debt you would have to pay back in Chapter 13, but we should probably be able to keep all of your assets, whether they're exempt or non-exempt, in a 13 or in a 7. The other difference I see is in Chapter 13, you can eliminate loans on a house, in particular a second loan. I see that a lot lately over the last couple of years, whether it's in my San Diego County office or in my Riverside County office, where people are trying to eliminate second loans. And the example I give to people is, let's say you have a house that's worth $250,000. Let's say you have a first loan that's $270,000, and you have a second loan for $100,000. Well, what you would need to do, if you could, is to get rid of that unsecured debt against your house. In other words, the second. And through a Chapter 13 bankruptcy, you can eliminate that second over the course of the period of time you're making payments to the trustee. It will be eliminated. Chapter 7, you cannot do that. So that's a big difference, and a lot of people would want to file a 13 merely to get rid of a second in a house. That happens a lot. The other difference I see in a Chapter 7 versus Chapter 13 is possibly reworking car loans and other loans on rental property that can be done, whether that's in San Diego County or in Riverside County. It can be done. And the difference between a 7 and a 13 is a 13 you can manipulate the amounts owed and eliminate certain loans on certain types of property that would normally be secured, such as car loans and real estate loans. There are also similarities between the Chapter 7 and the Chapter 13 in that when you file your bankruptcy, you are protected by the automatic stay of the U.S. Bankruptcy Court. So any legal actions, judgments, debtors' exams, garnishments, repo action, foreclosures will all be stopped immediately upon the filing of your bankruptcy. We stop foreclosures on a daily basis and save people's homes in either San Diego County, Riverside County, or other areas of the state which we may agree to take your case in. To decide if you qualify for a Chapter 7 or Chapter 13 bankruptcy, we first have to perform a means test for you, and that would be balancing your income versus your expenses in the computer program that the Bankruptcy Court authorizes that we have available in our San Diego County office and our Riverside County office. So if you contact our office, we can perform that means test for you either over the phone or in person to determine which bankruptcy would be best for you, either Chapter 13 or Chapter 7. The type of people or businesses that come to me for Chapter 11 bankruptcies are usually businesses with significant assets and significant debt. Maybe more assets than debt, maybe more debt than assets. Either way, the Chapter 11 allows them to reorganize. Chapter 11 is a reorganization bankruptcy, allowing you to keep things that you have going, to eliminate debt, to keep your business moving forward and get it out of a tough situation that it may be in. There's a difference between a small business Chapter 11 versus a non-small business Chapter 11. To qualify for a small business Chapter 11, you have to have debts totaling less than $2,343,000. And if you do have debt totaling less than that, you can qualify for the streamlined process of a small business Chapter 11 bankruptcy. The advantages of a small business Chapter 11 bankruptcy is a streamlined process that's used in providing a plan to the court and providing an exit plan to the court. So you can get in and out of a Chapter 11 bankruptcy much quicker, much cheaper than you would in a small business bankruptcy than you would in a larger business bankruptcy. The key to a Chapter 11 bankruptcy is reorganization. You want to stop foreclosure actions, stop collection actions, stop garnishment actions, whatever needs to be stopped. We would use that automatic stay of the U.S. Bankruptcy Court by filing the Chapter 11 and allowing you time to reorganize. Most likely you would be able to wait 3 to 4 months at a minimum till you had to pay any of your creditors any money. The court allows you a time to propose a plan that would reorganize and show the court that you're making your best effort to pay back all the debts you can, but you're asking the court potentially to relieve you from some of the debt that you don't want to have to pay within your business or corporate structure. Realize that Chapter 11s can be filed by a corporation or by an individual doing business. Please feel free to contact my San Diego office or my Riverside County office to decide if you can qualify for a Chapter 11 bankruptcy and be successful to keep that business going and profitable in the future.